the circle. We're all about um, coaching ourselves up to be the best version of ourselves. So one moment, and it's 7:00. So you're here, you're on time. We're going to go ahead and get started. And greetings and welcome to Kingdom Harvest Sister Circle. I can't believe that I got a call coming in and I forgot to silence my phone. But we're having our time right now. Sister Circle, you all know what we do here is a safe place for women to get equipped and empowered, informed, engaged, and we're the better for it. And so we've had a wide range of topics that we've covered through the months of the year. And we've been doing this for a couple of years, but we've done everything from health. We've even had our wonderful friend, Gwendolyn Briley, actress Gwendolyn Briley Strand. You all might recognize her. She even did her well-renowned play, Harriet. So we've had health topics, stress management, grief management, how to be successful, how to be victorious, how to be effective, how to live our best lives. God says he came to give us life, and we don't just want a life. We want what he promises.
Abundantly.
Life more abundantly. And so part of having an abundant life is being informed and aware, equipped, and enlightened. So in this space, we get enlightened. I'm giving everybody a few more moments to log on, but I'm so grateful that you ladies, it's Friday. And here it is. We are gathered on this sister circle. You all probably know the history. I've shared it multiple times about how Sister Circle got birthed. The title, I know there are other organizations and groups called Sister Circle, but this was a real situation where a circle actually formed. We were in Washington, D.C., which is where I'm from, and my husband and I pastored there, and 6 blocks from downtown Washington. And there's a little strip, there's a lot of homelessness all over the country. And you all know that, but there's a little strip. Mitch Snyder was a hunger advocate, and he would go on these long fasts. So they named the whole street after him. And there are multiple shelters, homeless shelters. So one particular member of our church, we were looking for outreach, and she wanted to go there, and we followed her lead. We found out later she once lived there. That was something. But it was about 80 women from ages 18 to 80. And they were all in this little space, bunk beds. And we would call, there was nowhere to sit, no conference room, nothing fancy. Again, it was a place for them to lay their head. Nevertheless, we went there with our intention to be a blessing, take snacks and have a little Bible study, encourage everyone and sing and hope and just sing and be there for the women. But they were there for us because when we formed a circle, we created a circle, and we had great times. We sang songs, and what we learned is iron sharpens iron. Because someone is down doesn't mean they're out, and doesn't mean we should look down on them, because many of the women just simply fell on a hard time. So we again, gathering in this safe space where women can again find information and be a blessing to each other. The Lord said, I'll bless you and make you a blessing. But tonight we're going to do something very different and something we've never done before. We've had a financial guru. You all remember Priscilla, financial coach for and she did an amazing session for us. But tonight we're going to talk about something a little different to get some insights and perspective. And I have an amazing guest that I'm going to introduce in just one moment. But what I need to do right now is pray. Father, we bless and honor and thank you that this is a day we've never seen before, day we'll never see again. But we come in the glorious, mighty, matchless name of Jesus. And we know in your presence, you bring all your power and your glory. Holy Spirit, have your way. Open our hearts, open our minds, open our ears, open our intellect. So, Lord, we can be the better for having spent this time together. Lord, we know that our speaker has prepared herself. She has an amazing wealth of knowledge she's going to share tonight. We thank you for her agreeing to just come on a Friday night. We thank you for all our guests, and whether they're watching on Zoom or Facebook or YouTube, wherever they're viewing from, Lord, make this message meaty and valuable, of great value. We want to add value to their lives, Lord. We thank you in the marvelous, precious, amazing name of Jesus, and we give you praise. Amen. So tonight, you all saw the ad, and it talked about getting your house in order. For my Christian friends, all of you probably know about the prophet who was dying, and he had to get his house in order, and the Lord told him that he would add 15 more years to his life. But here tonight, we're talking about our financial life and even our perspective on what we're doing in this life. You know, many of us spend our lives accumulating wealth, building wealth, and now we learn how to manage wealth. And this is all about preserving wealth and then passing it on, or your legacy. I always say there's a difference between legacy and an inheritance. Legacy is the things, the invisible things that we pour into people, the intangibles. But the wealth and the inheritance is the stuff that we accumulate as we travel through life. But tonight we want to look at how we should perhaps look at that and how we should prepare. If you there's so many people. In fact, today I asked a couple of people, "Do you have a will?" "No, but I need one." And it's interesting how we think we're going to perhaps get around the whole idea of passing away. We're here for a brief time, and then we go on to be with the Lord forever. But while we're here and enjoying our lives and living a full life, a full blessed life, we certainly want to put ourselves in a position to leave our affairs in order. So this young lady, this dynamic attorney friend that I met, I attended a workshop, and she was so effective. I had so many ahas I didn't know. And I'm sure you all have the same thing, the same experience that I had, enlightenment, because that's what she does. She'll enlighten you. And I asked her if she had a book or a resource that we could give away. She said, "No, I don't, but I'm encouraging that that's something she should do." And I'll be encouraging them. You'll probably agree with me when it's all said and done. But let me introduce her. But first of all, I see more friends have joined us. Let me welcome. Yes, I prayed. Yes. I have a coach back here said, "Did you pray?" I can pray again if we feel. No, I'm just kidding. Yes, we pray. We always pray. We always invite the Lord to be involved in our activities and ask him to be present. So thank you again for joining us. If this is your first time joining us, or just say hi in the chat. And what we want you to do as our presenter, Ms. Delman, presents, is if you have questions, put your questions in the chat box. I had plenty of questions, and hope you will as well, so we can gather them up. So she's going to share. Let me tell you a little bit about her. Her name is Jennifer Dowman, and she is an estate planning attorney with the law firm Walker Lamb, based in Durham, North Carolina. She's a native of Granville County in North Carolina. Jennifer earned her undergraduate degree from Duke University and her law degree from UNC of Chapel Hill. So she can cheer for either side of the blue. That's funny, right? And I bet she does. In addition to her busy law practice, Jennifer enjoys giving back to the community through volunteer and pro bono activities. She currently serves on the board of directors for the Ronald McDonald House of Chapel Hill and the Jitsu Foundation. In her spare time, Jennifer enjoys reading, traveling, spending time with her husband, Ryan, son, Alexis, and Oliver, and cat, Atticus. Well, I want to present to some and introduce to others my friend and attorney, Jennifer Dowman. Jennifer, we're going to turn it all over to you.
Great. Well, thank you so much. Thank you for the invitation. I absolutely love that this is a group of women supporting each other and growing together. And that's just, it's just such a delight to speak to you guys today. As Lady Byrd said, we're here to talk about estate planning. And with your permission, I'm going to share my screen because this is going to be, let's see, can I get that? Okay. Can you guys see what I'm seeing?
Yes.
Okay. So it's death and taxes, right? It's not necessarily a fun topic. It's going to be a little less painful, maybe, if we've got some slides to go along with it. But let's see. So what we're going to talk about today, well, Lady Byrd has already introduced me, so we'll skip over that bit. But we're going to talk about estate planning. What is it when we say estate planning? We're going to go over a case study. I think that's the best way to learn. It certainly is for me, hearing stories. And then if we have time, we're going to talk a little bit about long-term care. And one of the things, both in terms of estate planning and long-term care, is we're going to talk about how might a trust fit into your plan. So that's me again. So kind of first fact that I like to talk about is that even though we have 100% chance of dying, we all know that it's inevitable, right? 7 out of 10 people in North Carolina don't have a plan for what's going to happen when they pass away. They don't have a simple will. They don't have a trust. They don't have anything. And so that's, we all know that death is inevitable, but, there's all sorts of excuses we can make, right? I'll get around to it. I'll get to meeting with an attorney or preparing a will, but a lot of people don't. And so if you don't have a plan in place, what people don't realize, I think, is that the state of North Carolina has a plan for you. I don't know about you guys, but I don't necessarily think the state of North Carolina is doing a fantastic job managing its own resources and making decisions. And I certainly don't want them making decisions for me, my family, my wealth, who I'm leaving things to. The plan that the state of North Carolina has, for a lot of people, isn't the plan that they would want for themselves. And so the kind of example that I give of that a lot of people are like, really, why would they do that? Is that for a young married couple, no kids yet, one of the spouses dies, tragically. Most people would say, well, that they probably want everything to go to their surviving spouse. But the state of North Carolina says, well, the surviving spouse gets half, the other half goes to that person's parents. And so for some people, that might be the right outcome, but for a lot of people, that's not what they would have wanted. So not having a plan in place and letting the state decide for you, probably not the best plan. So we're going to talk about a story of a married couple, maybe like a lot of you guys. So meet Don and Jean. They both have retirement accounts. They've got some money in savings, and they've got their house, here locally that's worth $350,000. They also have 2 children. So Donna is their oldest daughter, and Donna is the perfect daughter. She was the perfect child, straight A student, never gave them any trouble, had her choice of any college that she wanted to go to when she was graduating high school. After college, went on and earned her medical degree. She is now a research physician in Atlanta, and she is doing a fantastic job. She's going places in life. Only thing that she hasn't given Don and Jean that they would really like for her to give them at some point is grandbabies. But she's doing really well, leading a great life. Don and Jean also have a younger daughter, Christy. So Christy is the opposite of her sister. She was a bit of a troublemaker when she was younger. High school, had some run-ins with the law, dabbled with substance abuse, got a couple of DUIs. When she graduated high school, she decided to not go to college, not that she could possibly get in anyway, but she wanted to pursue her dream of becoming an actress. And so she moved out to California. Discovered not too long after that it's hard to be an actress and it's hard to afford to live on a barista salary in Los Angeles. And so she ended up moving back in with Don and Jean, and she currently lives in their basement. Up until I was telling the folks at the seminar that I went to with Lady Byrd about this earlier, but up until about a year ago, I had one of those. I have a 23-year-old, and it took him until he was 22 to finally move out of the house. So I feel Don and Jean's pain with that, bird that leaves the nest and then comes back home. Planning options for Don and Jean, right? So what are their estate planning options? So one thing that they could do is do nothing. Let the state of North Carolina decide what happens to their assets. And for them, if one of them passes away, what the state of North Carolina says is that the surviving spouse would get half of assets and the other half would go to their kids. Not what they want. They could own their assets jointly with right of survivorship. That's a good option for some married couples. But then after the first spouse passes away, that's usually not a good option to own assets jointly with your children or with other folks. They could have a will. They could have a revocable trust. Either of those options might be viable for their family, but really the best solution is a plan that's specific to their family and goals. And so what might that look like? So their to-do list, this I might have recycled my own to-do list, except for the 40th anniversary trip. My husband and I have only been married for a few years. But one of the things that they know that they need to do is draw up a will. And so they actually decide to do that before they take a vacation. So they meet with the last attorney that they worked with, which in their case, probably in a lot of your cases, is the real estate attorney who helped them close on their house. So they met with the real estate attorney and they said, look, we've got a really simple situation. We've been married for 40 years. We have 2 adult children. We just want everything to go to the surviving spouse. When one of us passes away, when both of us have passed away, we just want everything to go to our 2 daughters 50-50. Can you do that? So the real estate attorney says, sure, that's simple enough. I can draw up a will that says that, and he does. And so he draws up a will that says everything to the surviving spouse and then to the daughters 50-50. So the rest of this is not to criticize that real estate attorney. The real estate attorney drew up exactly what they asked for. But I want you to ask yourselves as we kind of talk about what happens to Don and Jean next, whether that was really the plan that they needed. Shortly after they get back from their trip, their 40th anniversary trip, Jean has a car accident. She suffers severe injuries, both physically, she's now in a wheelchair, and a traumatic brain injury, which has kind of rendered her incapable of making decisions for herself. So the most immediate problem that Don has is that they live in a 2-story house. All of the bedrooms are upstairs. All of the full bathrooms are upstairs. And he knows he needs to sell that and get something that's 1 level that's going to be handicapped accessible for Jean to have a place to sleep and have a bathroom that she's able to use. Well, he goes to a realtor, and says, okay, my spouse is incompetent. We need to sell this house so that we can, get something. Can you help me with listing it? And the realtor says, well, no, not yet, because you and Jean own the house jointly, and Jean doesn't have capacity to sign the listing agreement. So we can't, and you don't have any documentation showing that you have the legal authority to act for Jean. So you can't list the house just yet. There's some other problems that he has. He needs to access Jean's IRA to pay her bills. He needs to talk to her and the insurance company to find out, doctors that are in network and to get authorization for certain treatments and things like that. And he keeps, running into issues every time he tries to call it, that he's told, well, I'm sorry, but under HIPAA laws, we can't release any information to you. We got to talk to Jean, but she's incompetent. So he's running into a lot of issues. Eventually, Don is going to be able to make decisions for Jean in this scenario. He'll be able to list the house and sell it. He'll be able to access her IRA. He'll be able to talk to the insurance companies. But first, he's going to have to go through a court process called guardianship. Guardianship is essentially, it's a 2-prong court process. The first prong is that there's a hearing to determine whether or not someone is legally incapable of making their own decisions. And then the second prong is if they are, well, who's going to make decisions for them? And there's a lot of problems with this process. One is the court's in control of both prongs. So the court, has a lot of authority here. Second is that it's expensive. So there's a fee to file this court proceeding. There is going to be a fee when Don is named as Jean's guardian based on the size of her estate. He's going to have to post a bond, and that fee to the court based on the size of her estate and the fee to post a bond, that's due every year, each and every year. So kind of a continuing cost. It's time consuming both up front to, get a hearing date, fill out the court paperwork, get a hearing date, and then to fill out the documentation necessary to be named as Jean's guardian. And it's time consuming every year. So every year, Don is going to have to report back to the court what he's doing with Jean's assets and get permission if he's trying to do anything that's out of the ordinary, like sell the house. And it's humiliating to the extent that Jean has any capacity whatsoever. She's being dragged to court where people are, asking her questions and trying to gauge her capacity. And so it's really, it could be humiliating for her. So lots of issues with guardianship. If you take away nothing else from this, hopefully you'll take away this, that everybody over the age of 18 needs 2 documents, a general power of attorney and a healthcare power of attorney. Those documents name somebody to make decisions for you, both financial and legal under the general power of attorney, healthcare decisions under the healthcare power of attorney, if you're not able to make decisions for yourself. My 23-year-old son, the week after he turned 18, I dragged him down to the office and had him meet with one of my colleagues to get these 2 documents in place. Because after he's 18, even though he didn't have any assets in his name, he's still under my health insurance. I'm still bankrolling him. And, he's still in high school. He's a legal adult in the eyes of the state of North Carolina. And so if he was in a car accident, had some medical emergency, I wouldn't have had absolutely no rights to make decisions for him in the absence of these documents. And so these are something that it doesn't really matter what your wealth is, what your family circumstances are. Even if you're married for 40 years, you still need these documents. And that way you avoid the court process of guardianship if you have an accident or become unable to make decisions for yourself. So a couple years later, Jean is going to pass away. Don is going to have to go back to court a second time to probate Jean's will. And a lot of people think you avoid probate with a will, and that's not true. It certainly can simplify the process. You can bypass some things that would otherwise be required, like your executor posting a bond with a will, but you still have to probate a will. So what is probate? Essentially, it's the court supervised process to transfer assets from someone who has passed away to the beneficiaries that are named under a will, or if there is no will, to the people that North Carolina says are their next of kin who will inherit from them. Just like with guardianship, it's a court proceeding, and so it's kind of long, drawn out. It's public. Your will becomes public record. The inventory of your assets becomes public record. It's time consuming. So if you live in Wake County in particular right now, Wake County is really backed up. I just got a document back that I sent off for filing in August of 2022 this week. I'm still waiting on documents that I sent in November and December of 2022. So they're about, 8 months or so backed up in Wake County. Durham County, Orange County, not as bad. Usually we get documents back within 2 to 4 weeks or so. But Wake County right now, I think, are having some staffing issues, and they've been backed up since the start of the pandemic. But either way, it can be a really time-consuming process. If you have real estate in more than one state, so you're a North Carolina resident, but you have a timeshare at Myrtle Beach, South Carolina, you're dealing with probate in 2 states, both where you live and where your real estate is located. And it's expensive. So court fees, publication fees, executors' commissions, attorneys' fees, they all can add up to take a pretty decent chunk out of your estate. So Jean has passed away. Don is getting his life back together after he's been a caretaker for Jean for a couple of years, and he meets Betty. And ladies, statistically speaking, if you pass before your husband's, there is an 80% chance that he will be involved in a new relationship within 2 years of your passing. I can surmise on the reasons for that, but that's just kind of what statistics are telling us. The opposite is true. So if it's the husband that passes away first, only 20% of women are involved in a new relationship within 2 years. Anyway, so Jean has passed away. Don meets Betty. They get married. Who do you think is going to end up inheriting from Don when he passes away? Maybe the kids, maybe Betty. Without a prenup, Betty's going to get a piece of Don's estate, even if he doesn't change the will. And so one thing that, we can talk about doing is, if you're concerned about this, there's ways to protect assets in the event that you pass away first and your spouse remarries. Sorry, my computer's being very slow, but there's Betty. All right, what if instead of getting remarried after Jean's death, Don starts to show signs of dementia and he becomes not able to make decisions for himself and ends up in a nursing home? Did he learn his lesson and get a general power of attorney? No. So we're going to have to go, his kids are now going to have to go back to court again to have him declared legally incompetent and to get somebody named to make decisions for him. Well, with Jean's guardianship, it was pretty cut and dry, right? She'd been married for 40 years. They had a great relationship. Her husband was, a perfectly mature, responsible person, the court's pretty much going to rubber stamp the husband's going to be the guardian for the wife in that kind of scenario. But now with Don's guardianship, he's got 2 daughters. So, and, Donna's going to say, well, I'm the mature, responsible. And of course, you should name me as guardian. But I think Christy's actually got a really good argument. She's going to say, Your Honor, Don is incompetent. He needs somebody that's local, who's able to drive him to doctor's appointments and, be there for him and make sure he takes his medicine. And yeah, while Donna's got a fancy job and she's great and all the education credentials, she's so busy at that fancy job of hers that, she only made it up to visit her dad twice last year. Donna, meanwhile, she put her career and her dreams of becoming an actress on hold to move in with her parents after Jean's accident. She's been helping take care of Jean, and now she wants to help take care of Don. And, she should be the one named as Don's guardianship because she's local and she wants to do this for her parents, and she's got the bandwidth. I don't know if that's a winning argument, but I can tell you that judges in North Carolina give a lot of weight to the child that's local. And so in the absence of pretty compelling evidence, otherwise, the child that lives here locally is going to be named as the guardian. And that's probably not what Don would have wanted because Christy's not the responsible one. So we've got the same problems that we had in Jean's case. I want to highlight kind of 2 particular things here. One is the expense, because now we've got both Donna and Christy that want to be the guardian, and they both hire attorneys, and they're kind of battling it out over who's going to be in charge of managing Don's affairs. And that's not cheap. The big winners in these are going to be the attorneys. And the humiliation. So if any of you have had a family member with Alzheimer's or dementia, that a big part of it for a lot of patients is paranoia, right? So I had a grandmother that had dementia at the end of her life, and she kept accusing people of stealing her jewelry that she had given away 10 years prior, or jewelry that was, still in her possession. But, she kept accusing people of stealing things from her. And that's kind of a common scenario that I hear is paranoia is a big part of dementia. So if you have somebody that's already paranoid, and that's a, part of the disease process, and then the sheriff shows up on their doorstep and says, your children have filed a lawsuit against you to have you declared incompetent to take control of all of your affairs, that's not going to be good for family harmony. That's not going to be good for Don's mental health, his anxiety. It's not going to be good for his relationship with his daughters. The fact that they're, fighting over who's going to be guardian isn't going to be good for their relationship with each other either. Because there's going to be lots of kind of issues here. So years pass by, Don passes away. We're going to have to go through another probate. Same problems as we had before. And we've got, all sorts of questions, now about, well, there's no surviving spouse, so who's going to pay for his funeral? We talked a little bit about at the seminar that I did before, funeral insurance might be a good option, especially if you don't have kids that, you want to burden or can't, don't have the funds, to pay for your funeral. You don't want to rely on a GoFundMe, and people contributing to pay for that. That's just when your family is grieving, not a great option. So let's talk about how the estate's going to be distributed. And are Don and Jean's daughters both ready for their shares? So I told you everything that I know about Donna, except for I omitted one fact earlier, which is that Donna is married to Jimmy, which Jimmy is basically every parent's nightmare, right? So Jimmy is kind of a good for nothing, doesn't have a job. Why does he need one? Donna makes plenty of money. Which would be fine if he were helping out around the house or with the kids, but they don't have kids, and, he doesn't help out around the house. He's just kind of mooching off Donna, and he's not very nice to her. And that's maybe the worst part is that, he's not good to her. He cheats on her. Don and Jean never could stand him. But what do you think is going to happen if after Don and Jean get married, 10 years later, Donna sees the light and leaves him, or even if Jimmy leaves her, she's probably going to end up with half of her inheritance, right? And so that's kind of one thing that parents, when they don't like their son-in-law or daughter-in-law, they want to avoid. Let's make sure that Jimmy doesn't end up with part of Donna's inheritance. But in the absence of planning, he might. Well, what about Christy? So Don and Jean are worried about lawsuits and creditors for her. So, first thing that she's going to do after she gets her inheritance is going to go out and buy a fancy sports car. She's going to go to the bar and have one too many drinks. She's going to cause a car accident. And whatever money didn't already get blown on the sports car is going to be lost to the people that she injured in that car accident. So her entire inheritance is going to be lost to her poor decisions. So let's talk a little bit about their real estate. So they have their house. So in North Carolina, unless the will specifically gives the executor permission to sell real estate or instructs the executor to sell real estate, what happens is that the minute the will gets filed, the beneficiaries own the property. So in this case, the minute Don's will got filed, Christy and Donna became owners of the real estate 50-50. Well, Donna wants to sell it. She lives in Atlanta. She has no need for this house in North Carolina, so she'd really like to sell it. Christy lives there. Christy wants to keep it. So we have a conflict about what we're going to do with this house. And, even if Don is nice and says, okay, let's fine, we'll keep it, so you can stay in the house, who's likely to be the responsible in paying for insurance and taxes and upkeep? Probably not going to be Christy, right? So, Donna would like to sell. She's prevented from selling because she'd have to, kick her sister out. And she's left being responsible for all these expenses. So that's not really fair. If they want to sell it, then not only do Donna and Christy have to consent, but Jimmy, spouses also have to consent to sell real estate. So there's a lot of issues with real estate, and regardless of what the plan is, whether it's a will-based plan or a trust-based plan, we want to make sure that we're thoughtful about what's going to happen to real estate and avoid conflicts, because this is one of those areas where, as an estate planning attorney, I often see families fighting over whether it's I want to keep the house and you want to sell it, or we both agree to sell it, but I want to sell it as is and you want to fix it up before we sell it, put some money into it. This is one of those areas where I sometimes see conflict. So Don and Jean's plan failed, right? So they had a will-based plan. They thought they were okay, but they didn't get the documents necessary to avoid guardianship, those powers of attorney. They didn't think about the possibility that the survivor might get remarried, and how are we going to account for that? They didn't protect Donna from divorce or Christy from her own poor choices. So there's got to be a better solution, right? So what's the better alternative? What's the happy ending for this story? So one of the things that I might introduce to a couple like Don and Jean is the concept of something called a revocable trust. So a revocable trust, the revocable part just means that they can change it. So as long as Don and Jean are alive, the document that they put in place, they can come back and amend, just like you can change your will, you can change your revocable trust. So if they want to be more or less restrictive with how their daughters inherit or who they want to name as beneficiaries, they can do that, acting together while they're alive. Within a revocable trust, there are three roles. There's the grantor. That's the person that sets up the trust and funds it with their own assets. There's the trustee. That's the person that manages things while they're in the trust. And then there are the beneficiaries. So those are the people that benefit from assets that are in the trust. So while Don and Jean are alive, they're in all three positions. They're the ones that set up the trust. They're the ones that manage the assets while they're in trust, and the assets are still there for their benefit as beneficiaries. So they control everything. There's no changes in their tax bills. It's really business as usual. But the trust is going to make things a lot easier when life events happen. So the trust is going to have really kind of talk about multiple different scenarios, right? So it's going to say, well, while Don and Jean are both alive and they both have capacity, here's how things are managed. When Jean has her accident, well, here's how things are managed after that, and she becomes incompetent. It's going to have provisions in place that say, well, what happens after one spouse passes away? And then it's going to have provisions in place that say, well, what happens after both spouses have passed away? How are the children going to inherit? So Jean has a car accident. She has the same injuries as before, but with the revocable trust, there's no court proceeding because their assets are owned in trust, and the trust has instructions. It says if Jean fails to serve as trustee, Don becomes the sole trustee, and he's directed to use the money and trust and the assets and trust for the benefit of himself and for Jean as they need it. So he's going to be able to immediately put the house on the market, sell it, get something that's handicapped accessible for Jean. He just doesn't have to wait for an expensive, time-consuming court process to do that. When Jean passes away, Don's not going to have to go through probate because the assets that they have either will pass to him by beneficiary designation or will pass to the trust by beneficiary designation, or owned in the trust. So we're not going to have to go through a court process. So how are we going to protect against Don's remarriage? Well, I'll introduce the concept. We call it A-B trust planning. And the way that I remember that is A for the spouse that's above ground, B for the spouse that's below ground. So Don, the spouse that's still above ground, the living spouse, his assets go into what we call the A trust or the survivor's trust. So Don's the trustee of this. Don has total control of this. If he wants to leave this pot of money, which is his pot of money, to the new spouse, he can do that. But Jean's assets will go into the B trust. So that trust becomes irrevocable upon her death. Don might be the trustee of that. We might have provisions that say Don is the initial trustee, but if he gets remarried or cohabitates with a romantic partner, Donna steps in and serves as trustee in his place. And, the assets are there for him for his benefit, but he can't leave them to Betty when he passes away. Whatever's left over goes to the kids. And we probably have a provision in there that says the assets in that B trust are only available to him if he depletes the assets in the A trust, right? So use your own money first to take care of you. But if you run out of money because long-term care, health needs, whatever it might be, well, then absolutely Gene's assets are available to tap into to meet his needs for the rest of his life. But whatever's left over at his death goes to the kids. Don can't cut them out, leave things to Betty. So we can protect against remarriage with this type of planning. So if Don starts to show signs of dementia and is placed in a nursing home, the trust is going to say, well, Donna is the successor trustee. So she's going to be able to make decisions, sell the home since he can't live there anymore, manage the money in the trust. We're not going to have to go through guardianship again because the trust has provisions about the money still there for Don's benefit, but somebody else needs to manage it for him now, and that somebody is Donna. When Don passes away, family's going to avoid court. Trust is going to be especially useful because it's going to say, give Christy 6 months to find alternate housing, but then put this house on the market. We're not going to hold on to it forever and ever. We're not going to deprive Donna of her inheritance because her sister wants to live there. So the trust will have instructions, whatever Don and Jean want to put in there, but the trust will say what to do with real estate. How are we going to protect Donna from her kind of poor choices in love? So we're going to leave things to her in what we would call a divorce or asset protection trust. Because she's financially savvy, she can be her own trustee. So she's the one that's managing the trust fund. Donna and her future children, if she has any, are the beneficiary. So the money's there for her if she needs it. But because it's kept siloed in this trust, it's not just given to Donna where she's going to put it in the joint bank account with Jimmy. It's kept siloed. And then when they get a divorce, he's not going to be able to touch a penny. Another side benefit to Donna as a physician is that this money is also protected from creditors. And so if she has, a malpractice suit filed against her or something like that, her personal assets are exposed, but this trust is going to be protected from any potential creditors. So we've been able to give her a significant amount of control over access to this inheritance, but protected it. So what about Christy? So we're going to put things for her in an asset protection trust. Christy's not going to be her own trustee. So part of the conversation with the client like Don and Jean is going to be, well, who should be the trustee for Christy and manage this pot of money for her? The knee jerk for a lot of parents is, well, it's named Donna, my responsible child. That's not going to do a whole lot for sibling harmony. And so a lot of times we like to say, well, is there anybody else in the family? Are there any, siblings, aunts and uncles, nieces and nephews? So people a little bit more removed from the immediate family that can manage this for Christy. Assets can be used for Christy. Absolutely. We don't want her to go homeless. We don't want her to go hungry. But she's not going to have direct control of it. The trustee will dole it out to her as she needs it. So it's going to be protected from her own poor choices, and from any potential creditors that she might have. So, kind of to recap what the trust has done, we've kind of protected against guardianship because everything's in the trust. Jean became incompetent. Don immediately was able to take over control as the other trustee. We've protected against Don's remarriage after Jean's death by setting things up in this kind of AB trust where Jean's assets are protected in an irrevocable trust that Don can't change. And then after the death of both of them, we've protected Donna's inheritance from divorce and Christy's inheritance from her own poor choices. And we've done that in one document. So it's a really flexible tool that we can build in a lot of really robust provisions and to protect against some of these kind of common things that we see in a lot of families. One of the things that we can sometimes build in, and I know we're running a little bit out of time, so touch on this very quickly, is, for somebody like Christy, we might want to build in incentives. So Christy, if you go to college and graduate, you're going to get a one-time lump sum payment from the trust, or, we'll match your earned income. So if you, work and make a good income, you're going to get an equal distribution from the trust. And so we can build in incentives for beneficiaries that might be struggling a little bit in life. So that's one thing that we can kind of get creative about. What behaviors would you like to encourage for somebody like Christy? And what financial incentives can we build in even after you've passed away to help encourage those? Beneficiaries with disabilities, we want to make sure that they're protected. If you have a loved one that is now on SSI, Medicaid, other needs-based government benefits because of a disability, you want to make sure that you don't leave assets to them outright. Because if you do that, then they're going to be kicked off of that government assistance, because all of those have, limits of like $2,000 in countable assets. And so you don't want them to kind of get kicked off of SSI or Medicaid because of an inheritance, spend down the inheritance, and then have to go back and reapply. And there's a gap in their benefits during that kind of application process. We can leave things to those beneficiaries in a special trust called a special or supplemental needs trust, where it says, this trust isn't to be used to disqualify them for those benefits. It's to be used to supplement government benefits and provide them with a higher quality of life. So we don't want to cut those beneficiaries out, but we want to make sure that we're thoughtful in the way that we include them in the plan so that they don't have benefits that are disrupted. And then blended families. I'm part of a blended family myself. So my older son is from my first marriage. I'm now happily remarried, and we have a almost 2-year-old. We're actually celebrating his birthday tomorrow. And so, I know I'm part of a blended family. A lot of my clients are part of a blended family. And so it's really, there's some complicated issues there, right? I want to make sure that my spouse is taken care of. How should I be fair between my older son from my first marriage and the younger son from this marriage? How can I make sure that, everybody gets a piece, of whatever I have to pass on? So you want to be really thoughtful if you're part of a blended family about making sure that you're fair to everybody, everybody's taken care of, and there's absolutely tools to do that. Other elements to consider, asset ownership and beneficiary designations. So we've really only talked about the legal documents, and those are absolutely important, but just as important is making sure that the way that your assets are owned and your beneficiary designations are set up is in sync with what the plan says. If you have a trust, you want to make sure it's funded, that you've moved cash accounts, brokerage accounts, stocks, bonds, things like that, real estate into the trust. If you have a trust for a beneficiary, somebody like a Christie, you want to make sure that your life insurance is payable to that trust, that your retirement accounts are payable to that trust, and not to Christie individually. And so, whatever estate planner you're working with to set up the plan, they should not only provide you with a set of legal documents, but they should also be providing you with instructions for, this is how we want your accounts titled. This is how we want beneficiary designations set up, so that those are consistent with what the legal documents say. Family issues. And so that's, oh gosh, that's, everything, right? From, how do we protect Christy? How do we protect Donna? How do we protect against remarriage? But also just things like, what are the family dynamics in terms of who we're naming in decisions of authority? So I like to tell the story of, a client of mine that came in and they said, I have two sons. They're both mature, responsible, wonderful. Can I name them as co-executors? And we talk a little bit, and it turns out they are both mature, responsible, wonderful sons. But then I asked the question, well, how do they get along? Oh, they can't stand each other. They haven't talked in years. Well, are they going to be able to get along and come together, to help administer your estate after you're gone? Maybe, maybe not. But if there's family dynamics that, can be landmines, sometimes we need to work around those. Tax planning. So, thankfully, we have a pretty generous estate tax exemption right now. It's $12 million per person. That's going to sunset back to about $6 million per person effective January 1st, 2026. That's still more than most. That's still more than I certainly have. That's more than most of my clients have. But for those that do have a taxable estate, and in some cases, people don't even realize it, right? They own a lot of land, and it's farmland, and it's always been farmland. It's been in their families for many generations. But as it turns out, because of its proximity to 540, it's now worth a lot of money. And so if you have assets, and you're over the estate tax exemption, that's something that we want to do to minimize the burden of those taxes on your family. And then long-term care planning. And the next part of the seminar was talking about long-term care planning. I actually don't know that we have time for that. Lady Byrd, what do you think? Should I hit on that briefly, or should we kind of switch over to questions? I want to be respectful of everybody's time.
I think we should. I think that there's some aging baby boomers, and I'm one of them. But guess what? We all have parents. And so, most of on the line may be feeling, oh, none of this pertains to me. I don't know what they're talking about. But information is power. And what we want to be able to do is have power to at least know what we don't know and then seek further information. So what you've done tonight, I'd like you just to touch on it. Perhaps if we don't have need for the information, we're in a position to pass it on or share it with someone. And I think that's very important.
Okay, well, I'll just take maybe 5 minutes.
Thank you.
And talk a little bit about kind of hit the high points. And so I think one of the high points is that about 40% of us are going to need care outside of the home at some point. There are really three different options, or I guess I should say we'll need care. One option is to have care at home, and that's either to have family members or paid caregivers, come into our home to take care of us, or move in with a family member. There's assisted living, which is a more residential setting, but they help with some activities of daily needs. And then there's skilled nursing facilities, and that's what we think of as more of kind of a medical setting for people that are usually require significant medical care, and they're often bound to their bed. And there's one of the common misconceptions that I hear is that, well, after 65, I've got Medicare, that's going to pay for everything. That's going to take care of it. Medicare does not pay for long-term care. That is a huge gap and I could rant for a very long time about the problem that is, long-term care and how Medicare won't pay for it. But as of right now, Medicare is not going to pay for long-term care. So there's a few options that are available. One is private pay. So that's just paying out of pocket for care, and that can get really expensive. The average assisted living facility costs about $8,000 a month. The average skilled nursing is probably closer to $14,000, $15,000 a month. So for most of us, that's our assets would be depleted pretty darn quickly if we need care in a facility type setting for any length of time. For private pay for somebody coming into your home to take care of you, that's even more expensive. I think right now, caretakers, it's kind of $18, $20 an hour. So if you need 24/7 around the clock care, that gets really expensive really quickly. Long-term care insurance. So for those of you who are younger, maybe in your 50s, even kind of early 60s, if you're healthy and you qualify for long-term care insurance, that's something I would encourage you to look into. I don't have a dog in the fight. I don't sell long-term care insurance. But I think long-term care insurance is a really wonderful, flexible option, because long-term care insurance will pay for care at home, care in a facility, kind of whatever you need. Some of these other options that we're talking about won't. VA aid and attendance. So that's a pension program that's available for veterans and their widowed spouses, and it'll pay for care at home in an assisted living facility or a skilled nursing facility. But it's kind of an income supplement, and so it's not going to fully pay for care. North Carolina Special Assistance. So North Carolina is one of the very, very few states that has this program that'll pay for assisted living. But this requires both has both a resource limit, so you have to have less than $2,000 in your name, and it has a income limit. So it's less than about $13,000 in income. And so for a lot of people, just their Social Security is too high for them to qualify for special assistance. But that's one program that's available to pay for care in an assisted living facility. So it's a really nice kind of option. And then you've got Medicaid, and that's what people traditionally think of when they think of paying for long-term care. One of the drawbacks in North Carolina is that Medicaid will only pay for care in a skilled nursing facility, won't pay for care at home, won't pay for care at an assisted living facility. And so I unfortunately have a lot of, family members that come to me and they say, Mom really needs care in an assisted living facility, but, and she's been there for 2 years, but we've completely run out of assets. And her income is too high for special assistance. Like, what are we supposed to do? And they end up going to a physician and having a physician kind of, certify that she needs care in a skilled nursing facility, even though she's probably really doesn't. She's probably fine at that assisted living facility just because there's no other option. It's either bring her home because she's out of money or get the doctor to say she needs that higher level of care in a medical facility versus the residential facility. And that's a really sad thing that I see happen a lot. So Medicaid is there. It's a safety net. It's a really, if you have low resources, so less than $2,000 for an individual. For a married couple, if there's a spouse that's still at home, they're allowed to keep up to about $130,000 of assets. So we don't have to completely deplete assets for a married couple. And for a married couple, there's ways that we can preserve more of their wealth. But those are really the kind of options that we have available to pay. But there's kind of holes in coverage. Let's see. I should have gone back a little bit. So one thing that we like to talk about with Medicaid is that they're accountable and non-countable assets. And so if you know of somebody that's kind of imminently going to a nursing facility, they have more than the required, the resource level. Sometimes there are things that we can do because there are assets that count towards that limit and there are assets that don't count. And so sometimes we can shelter some of, or even all of somebody's assets by moving things from the countable column into a non-countable column by, investing their wealth in slightly different ways. Irrevocable trust is an option. I know Jamal had asked me to talk about this at the other seminar, that's available if kind of you're planning well in advance. So with this option, we're really assuming that you're going to be healthy for at least 5 years, because this is essentially a gift for Medicaid purposes when you put property in this trust. And so that starts the clock ticking for that 5-year look back period. So if you make any gifts within 5 years of needing care in a facility, Medicaid will penalize you for those gifts. So with this trust, though, if you have 5 years before we think that you'll need care in a facility, you can transfer assets into the trust, retain access to the income. So not the principal, but the income. And then when you pass away, they go to your children. So they're not countable against you, even though you retain access to the income after 5 years if you need care in a facility. So that's a good option for some people that they kind of see the writing on the wall. Alzheimer's runs in their family. They feel like they're likely going to need care at some point in the future, but they do the planning well and, far enough in advance that we can make a gift and then kind of wait out that 5-year look back period and preserve. Especially, I have a lot of people do this for kind of family property. So the family farm, the family business, things that have been in the family for a while, and they want to make sure it's there for the next generation. This is an option that for some people can explore. Other options. I'm skipping around a little bit, but we talked about kind of changing things that are countable to things that are non-countable. We talk about like if your primary residence is a non-countable asset, if you've got a mortgage on your house, turn the cash into equity in your house because the house is non-countable while the cash is. So just pay off the mortgage. Prepaid irrevocable funeral arrangements are not countable. Tenants in common real estate. And so, if you have an adult child that's willing to kind of co-invest in a piece of property with you, even, they don't have to invest the same amount, but something that's currently considered a non-countable asset for Medicaid purposes. And then asset transfers between spouses. And so depending on what program we're looking at, for special assistance, the assets of the spouse that's at home isn't countable at all. And so you can transfer $1 million of wealth to the spouse that's at home, and the spouse that is in, needs care qualifies for special assistance if their income is low enough. Medicaid, there is deeming between spouses, but it's one way that sometimes that we can preserve some wealth. Medicaid compliant annuities are another one. I'm not a huge fan of annuities in general for most clients, but there are annuities that are really good because they're non-countable for Medicaid purposes for people that kind of imminently need care in a nursing facility. There's a lot of different options for planning. They're really specific to the kind of individual clients, what types of assets they have and their family circumstances. But there are ways that we can help people get qualified for these government programs that are available to pay for care. And that's it. That's I think I went closer to 10 minutes on the long-term care spiel, but hopefully it was helpful, at least at a high level.
My God, you've shared so much information, so much valuable information. I actually heard this presentation before and yet have more questions, but let's give her a hand of applause, everyone. We so appreciate your expertise and the fact that, as an attorney, why did you choose estate planning as an area of practice? Just curious about your story.
Oh, that's a little bit interesting. So, I kind of fell into it. So after undergrad, was a single mom and, working and, had always been thinking about going to law school and really wanted to go to law school. But before I invested 3 years of my life and got myself 6 figures in debt with student loans, somebody suggested, well, why don't you, go to work for a law firm and get some experience and just make sure you know what you're getting yourself into. I'm the first one in my family to go to college. I don't have lawyers in my family. I didn't even know lawyers at that point. And so I thought that was really good advice. And so I got a job working for Walker Lamb, the firm that I'm at now, as a legal assistant doing estate planning.
Wow.
That was my let's get the foot in the door and make sure I'm going to enjoy this. And I absolutely fell in love with it. I fell in love with the firm, fell in love with the clients. I fell in love with what we do. And so that kind of cemented my desire to go to law school, but also I knew kind of going in exactly, this is what I want to do when I graduate. And I've been there ever since. So I've been at the firm it'll be 18 years this August. And I love it.
Well, you're a walking wealth of information. And so we've demonstrated that. And I could see, it's interesting. I have a question. Attorney Delman, someone says, thanks so much for the info. I'm just curious. You highlighted the case study. I'm an educator, so I love case studies because there's so many facets to whatever the subject matter is that comes out in a case study. But you chose an African-American family. Mm-hmm. I'm just curious, why African-American family? And do you find that when you look at the different cultures, Filipina or Asian, African, people of different ethnic groups, Caucasian, do you see differences in how they approach estate planning? Just talk to us about that for a minute.
Yeah, well, so I think we try to have a diverse set of characters in our presentations, right? I think the kind of choice of characters was deliberate, right? So, we want to make sure that the case study that I'm presenting reflects the group that I'm presenting to. And so that was definitely a deliberate choice. And in terms of kind of the approach, I think, African Americans tend to sometimes have more of a distrust of rational distrust of institutions, yes. Right? Yes. Right. And so I think there's a little bit more of a hesitancy to get things in order, but sometimes, African Americans are the ones that can most, but they're the ones that I see most often losing their homes because they need care in a facility. And so they can most benefit from some of these things. And so, that's probably something that I could learn from you. What can we do to kind of get over that? And I think knowledge is the first, knowledge is power. Right? And so kind of educating yourself and attending things like this, so that kind of what are the options that are available. But I would say there's a distrust of some of the systems and a lack of knowledge about things that you can do.
Yeah.
I would say one of the things that I love about working with my African-American clients is that they tend to, I think, better than a lot of us white people do, is like stick together as families, right? So, mom might be less likely to end up in a nursing home because she has children nearby that are going to stick together and take care of her. And so I think that's something that Black communities do better than white communities in a lot of cases, is take care of people. And having communities like you guys, your church, you probably, organize meal groups for people after surgery. And you probably have any number of people in the Zoom room that you could call if you needed a ride home from the doctor's office. And I think,
absolutely, yes,
that's something that a lot of communities are more isolated and don't have as many people that they can reach out to. But there's definitely some differences. There's definitely a kind of bridge that we need or a gap that we need to bridge in knowledge.
Absolutely. And I'm so glad you made that distinction or brought out those points. While there are differences, well, being in leadership, especially in the church, we see so many families at the time of their most vulnerable and time of tragedy, when at the loss of a family member, patriarchs and matriarchs. Sometimes we find that there's such a disarray, and that there's lack of preparation. And that's why I felt so passionate about doing this. And someone would say, oh, I can't relate to anything that was going on in that case study. I'm looking for some questions. An excellent presentation. Thank you, Pastor Rice. And I see some Gwendolyn Briley. She says, wonderful presentation. So again, I want to know, what was your aha moment? Did anybody learn anything? I'm looking for some questions, but I do have a question. I'm an educator, like I said. There were 2 documents that she said, everybody on this line, if you're an adult, you need to have both of those documents. Can anybody tell us in the chat what those 2 documents are? And you got a door prize tonight. Okay, go right ahead.
Take care of your responsibility.
Yeah, but she said there are 2 documents that everybody, if you're
general power of attorney and a healthcare power of attorney.
There you go. Yeah. There you go. Thank you, Gwendolyn. And thank you. So make sure you put your email address there or your phone number so we can. So now tell us, I'm just going to be curious. Raise your hand if you have those documents. I don't have one yet. I'm going to do that. And I heard this presentation a month ago. Was it a month ago, Jennifer? Shame.
Yeah, it was about a month ago.
I've not gotten that together yet. So tell us how we do that. So did I see how many of you have it? Confirmation. My husband and I have our trust for 4 to 5 years. All right, Selena. Selena, we know who your husband is, Bishop. He's a money man. And he does money moves. There's Toshiba. Pastor Rice says, I do. Well, these are leaders, y'all, and we all need to be leading our own lives. So how many of you plan to do that? We just need some information how you do that and what is the cost associated with it?
That's a great question. And so kind of in terms of the process, we have some prospective client materials. I know I sent them to you, Lady Byrd. I'm happy to send them out to anybody. If you want to drop your email in the chat, I can send you kind of some materials. It just gives you a little bit more information about our process and fees and a questionnaire to fill out. Kind of the typical process is we meet for an initial meeting and kind of go over what's your family situation, what are your assets, what are your goals.
Now, are you talking about the power of attorney, or the power of attorney in the healthcare, or are you talking about a trust?
So I'm really talking about everything. During that initial meeting, we kind of dig down into what do you need, right? Do you just need the general and the healthcare power of attorney? Do you need a simple will? Do you need a revocable trust? Do you need an irrevocable trust? Do we need tax planning? So we kind of talk about, and that initial meeting is free of charge. And so there's no obligation to sit down and just talk about, well, what are my recommendations for what documents, might suit you. And then at the end of that initial meeting, I'm able to quote a flat fee, and I'm going to say 98% of cases, either, all you need are the powers of attorney and here's the fee, or you need a simple will and here's the fee, or you need a revocable trust or an irrevocable trust and here's the fee. The fee really depends on what are the documents. I mean, I think it's, anywhere, from kind of a really simple plan might be $500, if we need tax planning and, marriage protection, and we've got a Christy, and we've got a Donna, and we've got a special needs grandchild, and we kind of need more sophisticated. I mean, it might be 5,500. So kind of anywhere, so there's a pretty broad range, and it's because the plan is really customized. There's no one size fits all. I would say if you go to an attorney and they say a trust-based plan is X amount, whether it's 2,000 or 6,000 or whatever it is, and every trust-based plan costs that amount, you're getting cookie cutter planning. You're not getting a plan that's just like specific to your family. And so you should probably run from that attorney.
Individualization plan. So someone said, so again, when you get those documents filled out, how do you file them? How do you make them known? We have a safe in my home, a fireproof and waterproof safe where we keep our documents. Tell us, how do you file it, and where do you keep the documents if in your own possession? What do you recommend?
Yeah, it's a great question. So some documents will need to be filed at some point, other documents won't. So things like your healthcare document, so a healthcare power of attorney, an advance directive for a natural death, if you have one, if you want one. That's a document that says, I don't want life prolonging measures, if I'm kind of terminally ill or at the end of my life. We didn't really talk about that, but that's something that a lot of my clients want. Those you don't have to file anywhere. I recommend that you put those on file at your primary care physician's office, and that you share those with the person that you're naming as healthcare agent, so that they have access to that in an emergency, but they don't have to be filed anywhere. Your general power of attorney, it used to be the law that before it could be used, it has to be filed at the Register of Deeds. North Carolina changed the law. I want to say it was 2018 or 2019, and they kind of ended that requirement for everything except for real estate. So if your agent needs to do anything with real estate, like Don needed to sell the house and sign for Jean, power of attorney needs to be recorded. But for just kind of managing money, accessing IRA, selling the car, the general power of attorney doesn't have to be on file anywhere either. So it just needs to be accessible to the agent. The will, typically I say just, keep it safe. Don't put it anywhere until you've passed away. After death, the will has to be filed at the clerk of court's office in the county where you were living at the time of your death. Trust never has to be filed anywhere. It's private to your family, and that's one of the benefits of the trust. So it really depends on the document. And in terms of safekeeping, a lot of people do lock boxes at banks. I don't like those because of access issues. So unless the people that are your agents are co-owners of the lockbox, they're not going to be able to go to the bank and get those documents when they need it. So for my clients, we offer to store originals. And so that's an option for some people, that your attorney might offer to store the originals for you. And then you just have copies and you can call if you need the originals. Otherwise, a lockbox that you have at home, I think is a really good option. And just make sure that, the people that you're naming in the documents know how to get access. They know the combination, they know where you keep the key. But a lockbox at home that's like kind of, the fire resistant lockboxes where you can keep important documents is another good option.
Wonderful. I'd like the Bible says that people perish because of lack of knowledge. And so just not having this basic information, we find ourselves even losing opportunities. And you mentioned people losing their homes and just not doing the proper preparation. And I've seen that situation actually. The distrust in one family situation, my husband's family, he had children that were professionals. One was an educator, a principal, and the other was and she was an educator, but she was in administration. And another daughter was just as educated. He trusted no one. He thought, or the thought process was, and his friends told him, if you give your information, or if you give power of attorney to your children, they'll put you in a nursing home and then they have control and they won't let you out. Well, the distrust was so such that he never did. And when he died, he actually had an incident, went into a nursing home and he never made it out. He went into rehab and never made it out. And so the house was ownership was given over to the nursing home, and the family was so passionate about the house that they bought the house from the auction from the nursing home. And so it was so convoluted and so drawn out. And so that's one of my passions. How can we help people not find themselves in these situations? And when you ask for help, I see someone says, well, I went on LegalZoom. So even if you go on LegalZoom and do a power of attorney or health power of attorney, again, you don't need to file them. You don't need to publicly file them. Or I know in some instances, if you go get a medical procedure or like, for example, I have dialysis patients, they have to file their advanced directives, or if they have a power of attorney, health power of attorney on file. But where else should you don't have to put them in a public place. Just make sure that people around you have them. Is that what you're saying?
Yeah, for the health care documents. Yeah, the agents need to have access, and then usually medical providers. So if you have like a My Duke chart or My UNC chart, or what's it called, the My Portal or whatever it is, a lot of you can upload copies. For the LegalZoom, I've seen LegalZoom documents work fine. I've seen LegalZoom documents leave a family in total chaos.
Give an example.
Sure. So a LegalZoom document that led to a court battle was a lady said, I give to my daughter a life estate in my home in fee simple. So unless you're a lawyer, you don't probably know that those two terms are completely in conflict. So a life estate means that her daughter can live there for the rest of her life, but she doesn't actually own the house. It passes to other beneficiaries at daughter's death. Fee simple says daughter owns the house, she can do with it whatever she wants. So she literally left two different things to the daughter, and which one was right? Does she want the daughter to have a life estate, or does she want the daughter to have the house in fee simple, which means total ownership?
Say that term again, fee simple, FEE?
Mm-hmm.
Oh,
yeah.
Okay. Never heard of it. Mm-hmm.
Fee simple absolute is just the legal term for you own the house. And so, she pulled both of those terms from LegalZoom or whatever software she was using, not knowing that they mean completely different things. And that's something that, unless you've gone to law school, or you're a total geek and just, like to read old statutes, you probably don't know that that's in conflict. And so I read the will. I said, I'm not touching this because I don't know what she wanted to give, and I don't do litigation. I only do kind of planning and estate and trust administration where, it's kind of clearly laid out.
Wow. So I can only imagine that case you said it went to court?
It went, yeah.
And it cost the family more money.
Oh, yeah, because the remainder beneficiary, so the beneficiary who got the rest of the property was the decedent's son. And so the decedent's son says, daughter only has a life estate. I have the remainder interest as the remainder beneficiary. The daughter said, no, I have a fee simple interest out of the house. So I don't know. They both got litigators to represent them. And I'm not a litigator. I'm a planner. So I'm not quite sure how it turned out, but I know that's
very interesting.
We're going to court over that one. So yeah, I think that's the issue with some of those documents is that sometimes there are words that are used. I mean, it's the same for every profession, right? There are words my engineer husband uses that I don't know what they mean. And when you read over your LegalZoom document, you're probably going to see some words in there. You're like, I don't know what that means, but they're important. And you want to make sure that the words that you're using don't conflict. And so, I always recommend working, for the same reason that I also don't recommend going on WebMD and diagnosing yourself. I can go on WebMD and say, okay, I've got a sore throat and a runny nose and my stomach hurts. What do I have? But that's probably not going to be as good as going to a doctor and telling them my symptoms.
Absolutely. Yeah. That is so interesting. There's an old adage you're saying that if you fail to plan, you plan to fail. I heard you say I'm a planner. How many of you planned? So I need to see some questions. Thanks to Shiva. She says, great point. But we don't know what we don't know. Isn't that interesting? And I'm a learner, and I challenge us all to be lifelong learners. That means we never stop learning, and there's always something to learn. So what question?
Well, I was just going to say, sorry, one more to your question before, because you would ask about fees and I was trying to pull this up, but my computer was being slow. So I can share with you, if it'll come up. This is our schedule of fees. So we don't try to hide the ball. It's, so this is, there's like I said, there's a broad range. If all you need are kind of powers of attorney and things, you're down here. If you need, estate tax planning, remarriage protection, you're kind of in these, buckets. For simple wills, kind of we have lower. So we've got ranges. And, at the end of an initial conference, we could tell you like here, I think you're fine with a simple will, or I think you need, a revocable trust or whatever you need. And here's the fee quote. But this gives you an idea of kind of what the price point looks like, depending on kind of what the plan is. We're not the cheapest shop in town. I'm not going to tell you we are. But we're also not the most expensive. I think we're kind of in the middle and we're.
But here's what I know. I know there's some people who are looking at those fees and like, oh my God, that is crazy. I never would pay that kind of money. But you know what? Not to get in a situation and have to pay to get out of a situation is very, very dangerous and very, very risky. But would you say, I know there are legal clinics, for those that may not be able to, don't have spouses and they don't have the resources. I think about law schools, and sometimes they have legal clinics. AARP, can you tell those that may not be able to afford those fees, where they might be able to go to get further assistance or to get assistance? But what's happened here tonight, ladies, is that we've been exposed to certain terminologies. So when you go sit down, you know what to ask for, right. Or you have you can talk the language and then kind of know what direction, and know that one boot doesn't fit all. And I think that's the beauty of what you've done here tonight for us, Jennifer, is sharing a broad range of topics and insights. And the family, was that a crazy family? I don't know. That family is, well, not crazy. It happens. I see it all the time. But I like the trust that you can control things. Someone says, could you show the fees again? What I also like you to do is put your website and your contact information. And we're going to make this available on our YouTube channel for those that may have just joined us, or maybe you have further questions. And there's so much information, you all. Like some of you are probably checking, that doesn't apply to me, that doesn't apply. But I'm sure you saw something right out the gate. She shared that. But she wants to see that fee schedule again. There is that website. You all can go on her website of her law firm. And all that information will be there. And then the package, you have a link to the package that you send the questionnaire, because I'll be filling out that. There it is there. But look at all those different, now a simple will and will, you have a simple will and then you have will plans. And could you make that a distinction on that, or distinction terminology?
So for both of those, the plan is going to include a will, a general power of attorney, a healthcare power of attorney, a HIPAA medical privacy waiver, and if you want one, an advance directive for natural death. The difference to these plans right here is that with this, there's no what we call mandatory trust provisions. This one has mandatory trust provisions. And so a mandatory trust provision would be something like, I'm leaving things to my 2-year-old son. He can't inherit outright, so I need to set up a trust for him. I just want to set it up under a will, not under a revocable trust, because it's a little less expensive. So if you're leaving things to minor children, or I have the Don and Jean scenario, right? Don wants to leave things, if he dies first, to Jean, who's disabled. He's going to leave things to her in a supplemental needs trust or a special needs trust to preserve her eligibility for benefits and to have a trustee manage the money for her. Well, that's a mandatory trust provision that we can put under a will. So the simple will really is that everything is going outright to adult beneficiaries. The will plan with mandatory trust provisions is there's going to be some what we call a testamentary trust or a holdback trust under the will that has stipulations about how somebody inherits and how the money is going to be managed for them. So that's really the distinction. So the lower bracket is typically more appropriate either if there's a beneficiary with a disability that we need to set up a trust for, or minor children that are going to be beneficiaries.
I love the fact that with the daughter that you said, the daughter that liked to party and was a little irresponsible with her money, that the trust, because just like the lottery, people hit the lottery. And I think I heard a statistic the other day that said that 9 out of 10 people that hit the lottery are broke 10 years later. And what was that statistic that you shared with us at the beginning, Jennifer, that 7 out of 10 people
die without a will?
Die without a will. That's insane. Insane. And do you know, and look how long the court can tie up your resources and your monies and your assets. And I just think that we've seen it. Toshiba asked, what age should you start doing this? What are you referring to? Planning? Well, we know now when you're adult, you need your POAs, with power of attorneys, but what age should we start planning and setting aside monies and resources, or even thinking about our future in that way?
Sorry, I was looking at the comments here. So at 18, general and healthcare power of attorney. And honestly, usually when I have clients and they bring their 18, 19-year-olds, the fee is less than what you see in the fee schedule here. Those are kind of more comprehensive plans. If it's just like my 18-year-old needs documents, it's a couple $100. But 18, 19-year-olds, they need just the general and the healthcare power of attorney. That's really all they need. Really, people should start looking at a simple will or a will-based plan. When they start to have assets, so, they buy their first home, they, have a little bit of money kind of in savings, so they're working, they're starting to have assets, or when they have kids, because another important provision that we put in the will is who's going to be the guardian to have custody for your minor children if you pass away. So when you have assets or kids, you need a will. The trust-based plan, those are typically more for people that have a higher level of wealth, or, special needs beneficiaries, or there's some kind of compelling reason why we don't want people to have things outright. But in general, for 80-90% of people that have a trust, it's because they have a level of wealth that would make probate kind of more expensive and time consuming.
I remember there's a show that came on, and I remember the gentleman died, and he had money, and he told the attorney that was managing the trust, once he finishes his degree, he can get the money. And so the show is all his college days, and he's getting into all kinds of trouble trying to get this degree. And he even gets in a situation where he says, well, once I get this degree, I'll have money. But so what if the person never got the degree? What happens to the money?
The trust is going to say, right? So the trust will say, you get X amount upon your, finishing college, or, if by age 30 you haven't finished college, then, this gift lapses and goes to my favorite charity, or
that's
other kids.
That's one creative way to do that. You've seen that done, huh?
Oh yeah.
That is, what percentage of people, when they're given those kind of conditions, actually meet them? Most of the people try to meet those criteria. I'm just curious. I think it's a great incentive. You incentivize the what you like to see happen in that person's life. And it's probably something they need, education. I always say education. I think it was Malcolm X says that education is the passport to the future. So you can't go wrong with education. But have you ever seen where someone didn't meet the criteria of completing and they never got the money?
So I tend to see, I guess maybe because I prefer it, and so I recommend it, carrots more so than sticks, right? So instead of kind of penalizing you if you haven't gone to college by 30, you're out of the will. Instead, saying when you graduate college, you're going to get a lump sum payout of $20,000 or $50,000 or whatever it is. I don't know. I just feel like carrots are, a little bit more powerful than sticks as motivators.
I agree.
for the people that come in and they want to say something like that, like, I want to cut out my kid if he's not graduated college by 30. I mean, I like to point out, the Steve Jobs of the world and the people that didn't graduate college and were still really successful, or the fact that we need plumbers, we need electricians. And so if your child decides to go into the trades, that can be really lucrative. That's a needed profession. We need janitors. I mean, we need people of all different walks of life.
The pandemic showed us that we need everybody.
We need everybody. And so, I don't know that we necessarily want to tie academic. I'm a huge believer in academic achievement. If I could figure out how to get paid to continue going to school and just rack up degrees, I would be there 100%.
Oh, absolutely. I believe in trade and all those things. So I was just referring to that particular. There's another question, that particular show. How long can wills stay in place? Is it a time limit, and do they expire? Excellent question, Brittany.
No, that's a great question. They never expire. Now I encourage my clients, even after you sign the will, not to put it on a shelf and forget about it. Because a lot of times life circumstances change. And so it's a good idea to look at it and potentially to update it, periodically. But we've probated wills from recently from the 1980s. I mean, if you don't update it, that is your will until you pass away. Doesn't matter how old it is. The question is the person that you named as your executor 20 years ago still alive and appropriate, to serve as your executor? But if the answer is yes, then absolutely, it's still a valid will until you die.
So what is the criteria for looking for an executor? Executor is somebody that you leave to, you reference an agent. Is that the same or similar to an executive?
No. Similar skill set. It's so confusing because they have, different names in all of these different documents. So the person that's making decisions for you, if you're alive, but are not able to make financial decisions for yourself while you're alive, under a general power of attorney, is called an agent. The person making decisions for you under a healthcare power of attorney, if you're alive but can't make decisions for yourself, is a healthcare agent. So the powers of attorney name an agent or healthcare agent. The executor is the person charged with tying up your final affairs and distributing your assets under a will. And then if you have a trust as part of your plan, the person that's managing and distributing the trust assets is called a trustee. And that can be during your lifetime or upon your death. The trustee can serve kind of in either of those time periods. But there's different, you might hear the term fiduciary, which is an all-encompassing term. So fiduciary is really, what the word means is just somebody is managing assets for somebody else. And so an agent under a power of attorney is a fiduciary, an executor is a fiduciary, a trustee is a fiduciary. So sometimes we use that word to kind of encompass all of those different roles.
I understand that role is very regulated. They have a lot of laws that fiduciary, that they have certain strict guidelines that they should follow.
So anytime you have a fiduciary responsibility, essentially it says you're held to a really high standard. And so an agent acting under a general power of attorney is held to a really high standard. They have to be acting in your best interest, not their own best interest. An executor acting under a will has to be acting in the best interest of the estate and the beneficiaries, not in their own best interest. And so, fiduciary is just a higher level of responsibility towards someone else, whoever that someone else is. But it's there's a lot of laws that talk about what your responsibility is, in any of these capacities. But anytime you're acting as a fiduciary, you're held to a really high standard.
Well, I have a lot more questions. I don't see any more questions. I want to clarify something. In the case study, the husband, Don, if Don had a guardianship, he would not have had to go to court to do the probate, or would he have needed to have the trust as well? I got a little fuzzy there. How about you guys? It's a lot to it, right?
And I think I saw the time was like ticking down and I was flying through that part. So a general and a healthcare power of attorney, the goal of those is to avoid to avoid guardianship, because those are both dealing with, all three of those are if you're allowed but can't make decisions for yourself. A trust is avoiding probate.
Okay. So Don
that's
would have
what
been able to
process
sell the
that.
house had he had guardianship. Is that correct?
So when Jean's incompetent and Don's trying to sell the house, he can sell the house if he has a general power of attorney for her.
Oh, that's it.
Or if he has guardianship for her. The guardianship's just going to be a more lengthy and time-consuming process, because the court's kind of involved in having her declared incompetent and getting him named.
So what court is this that these matters will be filed in when you go to court?
Yeah, these are all matters before the clerk of court in the county where you're living.
Now I'm looking at my audience, our group tonight, our sister circle. I know that Anita is in North Carolina, Toshiba's in North Carolina, but Gwendolyn is in Washington, D.C., Maryland area, where I'm from. And I think I have some of my friend from Texas on. So how are the laws vary? Do you find, you probably are very familiar with North Carolina, but do you find cross state lines that things can vary quite differently?
Yeah, so for anyone that's on tonight that's outside of, for anyone that's on tonight that's in North Carolina, I could help with your estate planning. I would be happy to help with your estate planning. For anybody outside of North Carolina, unfortunately, I wouldn't be able to help because the laws do differ from state to state, and I'm only licensed to prepare legal documents for North Carolina residents. Now, certainly, reach out to me and say, hey, I live in Texas. Do you have a recommendation? Because, we have kind of a list of people that we've done business with, or, our clients have moved and they've come back to us and said, hey, I had a really good experience with this attorney in Texas, and so we've added them to kind of our list of referrals. So I might still be able to kind of get you a referral in that state where you live.
Awesome.
But yeah, the documents are going to be the same set of documents, but they're going to be slightly different, and they're going to reference kind of the different states. Here's the powers North Carolina or Maryland or Texas gives to their agents. So in general, they're everything that we talked about today, but the kind of specifics of them will be a little bit different from state to state.
Right. Now, I know a family that a will was established almost 100 years ago. Large land mass was their inheritance, and there were so many, but the wills weren't as specific as they are now. So when they present them to do you find that old, and that's probably that's a good question that the young lady asked in terms of age of the will, what didn't maybe 50 years, 75 years ago, specificity was not that required. And now when they present it to the court, it lacks that specificity and creates a challenge. Have you had that happen where wills are very old and they bring them forward and it's not enough information? What happens then?
Yeah, so it's usually not a matter of not enough information, but there's certainly, for some older wills, sometimes there are things that we're putting in newer wills that are missing. So an example that I can give you, so in North Carolina, about 5 or 6 years ago, North Carolina legislature amended their statutes, and they said, if your executor lives outside of North Carolina, you have to have this special language in a will, and you have to make this specific statutory reference if you want to waive the requirement that executor post bond. In the old wills, we just said, my executor shouldn't have to post a bond, period. And that was the end of the section. So, the new wills that we have say my executor should not have to post bond, consistent with North Carolina General Statute Section 36C whatever, even if my executor is not a resident of North Carolina, I, explicitly, request that they not be required to post bond. And so, the legislature changed the statute, changed a requirement for waiving bond. So a bond is, most people think of bond in the criminal context. Yeah. So most people think of bond in the criminal context, right? So if you're
that's the only context I know. So we need
so if you're charged with a crime, in order for them to kind of let you out, until your hearing, you might have to post a bond.
Yeah.
But in the estate planning context, in a fiduciary context, bond is sometimes required, if one person is managing assets for another. In a guardianship case, because that's kind of inherently, there's, legal documents lacking if we have a guardianship. So 100% of the time, if one person is named as guardian for the other, they have to post a bond. And that bond is just insurance that they're not going to run off with the ward's money. So the ward is the person who's incompetent. So if the guardian does run off with the ward's money, that bond, salesman, will pay it. So it's like insurance, right? So it's just, bond is essentially insurance. It's insurance. You're not going to run
protecting the assets.
It's insurance that the guardian's not going to run off. So when you don't have a will that waives the requirement, then an executor post bond. Either all the beneficiaries have to kind of sign something saying, the person that's going to administer the estate doesn't have to post a bond. Or, if there's minors, they can't waive that requirement. So the administrator will have to post bond. Or if the executor is out of state and that will doesn't have that certain language, they might still have to be required. So that's another kind of cost that can be involved in the probate process, is always involved in the guardianship process, is posting bond, is an insurance that, you're not going to abscond to some country with a non-extradition treaty and not give the money to the beneficiaries.
I have a question. My husband, we had a member of a church who's gone to be with the Lord now. She wanted my husband to manage or to be the executor of her estate. And she got sick and she had several hospitalizations. On the day that the day she went in the hospital, I think she kind of knew she was coming to the end. She hadn't filed the will. So she wrote things out by hand on a piece of paper, and they had to get a notary to come in and notarize it. But even that was very, very touch and go, and it was questioned and challenged even by her family, who thought at that point, was she compromised or was she? So it got so drawn out. And it's so interesting that you mentioned lock boxes. She had several lock boxes. She was a beautician, but she amassed and saved an incredible amount of money. We had no idea. And when the family went to, the family wanted to take control over everything. They had no idea what to do. Even my husband was quite baffled, or just like we're learning tonight, there's so many things, posting bond and agents and all that's required to do that. It's a very laborious task to get things managed. So when the family went to go to her lock boxes, she had a couple of lock boxes. One lock box was totally empty. So the family is then questioning. So it became it was so many problems with that. How do we avoid problems? We plan not to have problems, and we plan to get our house in order. That's what this is all about tonight, ladies. And you have done a marvelous, marvelous job sharing. I see some are asking, I'm going to make my appointment and learn more about I still have questions. I don't see any more questions, but I've written several questions down. I think that we don't know what we don't know. And then when we learn, we're empowered. And that's what this is all about, empowering and equipping and enlightening and encouraging ourselves to do what we must do to be victorious in life. Come on, ladies, let's give her another hand clap of applause and appreciation. Yes, 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 you deserve it. And I'm so grateful for my nephew, Pastor Brown, who had you, and along with several others. I see another question. I see that. LaShonda, you had a question. I see your hand is raised. But I don't want to leave any questions unanswered. You can go back and view this on our YouTube channel or our Facebook. But thank you, Jennifer, for an outstanding and for sharing. This is community work. This is community outreach, and especially in the African-American community. We find ourselves, most people, I don't have enough money, but the Lord said he gives us power to get wealth. So maybe you may not have all your wealth now, or what little he has. And we see in one scripture where there's the the story of the talents and the parable. He gave one talent, another 3, and another 5. And the one who did nothing, absolutely nothing with the one, he buried it. He didn't try to make it work or grow or do anything. The owner was very angry with him, and he called him some names that are not good names. And the others he was very proud of. So what power and what wealth we do amass, we do accumulate. We are required to manage it well, preserve it, and then plan to pass it on. Because guess what? We can't take it with us. There was one person, you probably heard this story, right? Where it says, I'm taking my money with me, write my check and put all my money in the casket. Well, guess what? He went away, but that checkbook stayed behind. But we want to make sure that we're in the best position to leave strong legacies for those coming up long behind us, that we teach them and even share the information that we've learned today. Gathering, do you find that people don't sit with their loved ones and have these conversations? I know when I was coming, my grandmother, I don't want to talk about that. Are you?
Yeah, it's interesting because so sometimes it's the parents, or grandparents, kind of older generation that's like, oh, I don't want my kids to know what I have. They'll, become kind of trust fund babies that'll stop their motivation. So sometimes it's the parents that are really private and hesitant, kind of like, I think you said it was your father-in-law maybe that refused to,
yes,
to kind of share information, or uncle, out of, concern that his kids will take over or whatever. So sometimes it's the older generation, sometimes it's the younger generation. So the parents are trying to have these conversations and the kids are like, no, I don't want to hear, you're never going to die, mom. And so so I've seen it on both ends. It works out better, when people are open and honest and they have these conversations, not only about your money, but about your healthcare and your preferences. And so things that, or even outside of these documents that we're talking about, if you're at the end of your life, do you want to be in the hospital? Do you want to be in a hospice facility? Do you want to be at home? What's going to keep you comfortable? And so things that are kind of, very personal. What does quality of life mean to you? And when would you want life prolonging measures to be withheld versus when do you want to keep fighting? So there's all sorts of things that, people really should be more kind of open and honest and have these conversations about. But yeah, there's, and I think that partially it's, our country, right? So it's such a taboo conversation to talk about death, but it's a natural part of life. And it's an important thing to talk about because that's kind of the worst case scenario when, I see, people that mom or dad just passed away and they don't know what mom or dad want. Did she want to be buried? Does she want to be cremated? So if you're not having those conversations, it's gonna come back to haunt your family.
Do you remember the case where the wife became incapacitated and she was on a tube feeding?
Very shy though.
Yes, and it was the husband wanted to release her, but her parents wanted to keep her alive. Maybe I got it the other way around. And it was in the court for a long period of time. I forgot that ruling. How did that rule?
So that was Terry Shivo. That's a Florida case. And I still use that when I'm talking to people about the advance directive. Although now I feel like I'm starting to get old because some of my younger clients, they're like, Terry, who? What court case are you talking about? Because this was like during, I guess, the 80s, maybe early 90s. So I'm starting to show my age when like my references are kind of too old for some of my folks that I'm working with. But yeah, so it was Terry Shivo, and she was she had a heart attack after I think like extreme dieting. And so she was young, she was in her 20s. She was in a persistent vegetative state, being kept alive by artificial nutrition and hydration. Her husband said she doesn't want to live like this, wanted to kind of discontinue that. Her parents said, no, we see her eyes fluttering. We think that maybe, eventually she'll wake up. Didn't want to discontinue it. The case made it up to the Florida Supreme Court. The Florida Supreme Court sided with the husband. But that was kind of the genesis for more of kind of the advance directive that I touched on very, very briefly is, people that were watching that said, geez, I don't want to live like that. And I don't want my family fighting over that. And so
good case in point.
Started putting it in writing. Yeah.
That's it, ladies. We've got to make sure we do our care business. Thank you. They're thanking you for an excellent job. And I want to join in. Thank you. You all know what we do. We are Kingdom Harvest Church, and we teach people to be disciples, to demonstrate, to discover, develop, and demonstrate the love of God in the earth and duplicate that love. And so, but one thing we like to do is also invite you to an intimate, close, real relationship with Jesus Christ, the Son of God, who came to die for us and was raised from the dead and gives us life and love, everlasting life, and promises life. If there's anybody on the line tonight who would like to be introduced or led into a relationship as simple as ABC, admit that you're a sinner, as God says, all have sinned and come short before God, and then believe in your heart, and then confess with your mouth, and you're in. Simple as that. And you're in for an eternity. Is there anyone tonight that would like to receive Christ as your Lord and Savior, your King, your Messiah? Please say so, and we'll pray with you. Or you can just put a note in the chat and we'll talk with you offline. I don't see any takers tonight. Well, I just thank again each and every one of you all for joining us tonight. I'd just like to pray a blessing over you all tonight. Father, we bless and honor and thank you for what our eyes have heard, what our eyes have seen, and what our ears have heard. We thank you for the presenter, a wealth of knowledge she's given us tonight. We thank you for blessing her to be in a position to help people and to do the outreach that she does, so that we would not find ourselves in situations and would not find ourselves ignorant. So we're the better for this hour and a half that we've spent together, and we thank you for it. We thank you that this information will not only help us, but generations to come. And as we find ourselves in positions to pass on information, give us those opportunities as well. Lord, you made us stewards over your kingdom, and you said, take dominion over every creeping, crawling thing. So you've given us opportunity and knowledge to manage and protect and take care of those things that you've blessed us with. Thank you for blessing us in the rich way that you have. We thank you and we praise you in the marvelous, matchless, miracle working, mighty name of Jesus. And all would agree with that prayer would say amen. Amen. Again, thank you, ladies, that were joining tonight. If you missed it or if you'd like to see it again, you can see it on our YouTube channel, also on Facebook, and just view it and share it, pass it on. Jennifer, thank you. Let's give her another hand of applause. You all have that number. If you need that, if you didn't catch it on the chat line, I can provide you her contact information. Again, now, is there a cost to your consultation?
The initial consultation is no obligation, no cost.
We should have said that. We lost a few people, but no cost, just for a consultation to find out what you need or what you, again, maybe you have some more questions like me. But again, thank you and God bless you. God bless you all. Next month, we're going to have a session on getting naked in marriage. That's from Reverend Renee Jones. She just wrote a book, Getting Naked in Marriage. Perhaps you're not married, but you'd like to be. It would be a good time to learn how you can get married or pass the information on. But it's called Doing Marriage God's Way and Getting Naked in Marriage. Tune in next month, third Friday in June, and then we're going to be taking a break after that. But again, thank you, ladies, and till we meet again, God bless. Thank you for joining Sister Circle.
Thank you, and thank you for the opportunity. Thank you for having me.
You're welcome, and thank you so much. God bless.
Bless.